For the record, this matter is before the court for continued pretrial conference, as well as the defendant's motion for payment on vehicle and other marital home expenses. This hearing is being conducted via Zoom, but present is Attorney Kirsty Nemec representing the plaintiff, Zachariah Garcia. Mr. Garcia is present. In addition, Attorney Eric Clark is present representing the defendant, Michelle Garcia, and Ms. Garcia is present. Good morning, everyone.
Good morning, Your Honor.
Have the parties made any progress toward the resolution of anything this morning?
They have not, Your Honor. We have one agreement, which resolves Mr. Clark's motion, but other than that, the parties have made no progress.
Okay.
Well, I was going to give the court the benefit of the doubt and say we actually made progress and by resolving the motion.
Okay. The court is in receipt of a recommendation from Ms. LaPrade, which states as follows: that the van shall be fixed. Plaintiff shall take the van to Dalkers and pay for the van to be fixed. Defendant shall pay half the cost to fix the van out of her portion of the proceeds to sell the marital home. That is the recommendation of Mr. Walker. Is that a correct, accurate statement of the parties' interim agreement this morning?
It is, Your Honor.
Yes, Judge.
Zach,
And when will Mr. Garcia retrieve the van and take it to Dalkers?
when will you be able to do that?
I'm going to call it because you have to set up an appointment for it to come in.
Yeah.
Okay, and you'll make that call today?
Yes.
Okay. So the plaintiff will be without that van for a period of time. Is that correct? Who's ever driving the vehicle?
They've said it'll take a week or so to fix.
Okay. And who is primarily the driver of that vehicle? The defendant?
Yes.
Okay. Does she have another vehicle?
I'm sorry, Judge.
Does she have another vehicle? Obviously, we have children involved here. Does she have other means of transportation being without this van?
Not really.
Not really. She used her mother's vehicle to get to my office for today's mediation and hearing.
All right. Okay, what about the other home expenses? Propane refill, water system repairs? Was there an agreement on addressing those issues as well?
Your Honor, those issues are actually non-issues. Mr. Garcia has always had those two items on an automatic refill. So when it comes to the propane, it is refilled when the tank is at 20%, and that happens automatically. Ms. Garcia was attempting to claim that Mr. Garcia hadn't paid the bill related to that expense. As the court is probably not yet aware, Mr. Garcia is no longer spending time at the marital home. The bill for propane is physically left at the home when the propane tank is dropped off. Mr. Garcia was not made aware that the bill was dropped off. Ms. Garcia should now know that when the bill is dropped off, she needs to make Mr. Garcia aware of that. With regard to the water softener, that also, the salt is dropped off automatically. It also requires peroxide. Mr. Garcia is purchasing the peroxide and dropping it off today. But the water softener does not affect the actual health of the water. It's still usable when the water softener runs out. But he will be providing the peroxide today, and the salt is already there. But on that note, you're welcome. Thank you.
Judge, actually, my client received a call from the propane company indicating that there was a balance due, and they wouldn't release the information to her because her name is not on the account. I tried to call myself. They wouldn't release the information to me either because my name obviously is not on the account.
Okay. So
But in any event,
between the parties, that's all.
It's been resolved.
Okay. All right. Good. So obviously, have the parties agreed to list the marital home for sale?
Yes, Your Honor, and I'd actually like to address that. I understand that I don't have a pending motion before this court. I believed that we'd have some resolution at mediation today, and unfortunately, that was not the case. The house has been listed for sale. However, Ms. Garcia is limiting walkthroughs to after 4 o'clock on Monday and Friday. And so that is impairing the ability of the realtor to get the house sold. In the meantime, Mr. Garcia is managing all of the expenses related to the home. Ms. Garcia has no obligations with regard to those expenses. There is a status quo order in place from our first motion hearing. We wanted today to come to an agreement to set that status quo aside and replace it with child support and spousal support. However, we were not able to come to that agreement. I don't believe that Ms. Garcia has any incentive to resolve this case or these issues, so long as she's able to remain in the marital home, prevent it from being sold, and have all of the bills paid. So we would like to
That's
see.
not true. She feels trapped. She's trapped by this situation. Mr. Garcia makes over $100,000 a year, took his paycheck, no longer deposits into the joint account, and she has to survive on $350 a week with 5 minor children.
That's not true either, Mr. Clark. She makes money.
That's what the status quo is.
She makes money. She retains
and the
money.
reason that she only shows it on those 2 days those are the only 2 days that the 5 children are not there. It's very, in fact, the realtor suggested that they not be there when they're showing because there would be a distraction, quote unquote. There's 5 little kids.
Mr. Clark, obviously we need to make this home more accessible for potential purchasers. So maybe Miss Garcia simply just has to maybe go outside or go to the grocery store, run an errand when the home is being shown. We can't restrict it to when the children are present. The children live in the home. We understand that, and obviously it's best for everyone that the children not be there, but we need to make the home more accessible. So there appears to the court that she can just simply.
I did. I offered a 3D video of it.
All right, hold on. All right, Ms. Garcia, I'm talking with your attorneys. So the court will order Ms. Garcia to make the home available to showings. And you got to make it happen. And obviously, to the extent we can sell the home, that's going to provide some financial assistance for Ms. Garcia.
Your Honor, on the issue of the home as well, there are some repairs that need to be made. The realtor suggested to the parties that if they invested $10,000 to $12,000 in repairs, they would realize profits of about $50,000. Mr. Garcia would like to get those repairs made, but needs Ms. Garcia's cooperation to do that. He would also like an agreement from Ms. Garcia that she'd be responsible for half of those repairs. She wouldn't have to pay for it up front. Mr. Garcia would handle that, but her half of any of those repairs would come from the proceeds of the sale. The same agreement that we have with regard to the repairs for the vehicle.
Well, again, Judge, this is something the realtor has not told my client. If she's recommended it, maybe it would be good for the realtor to call and advise Michelle of this instead of it being part of a hearing here today. But
did Ms. Garcia sign a listing agreement?
Yes.
And
Mr.
the realtor
Clark,
did not mention anything to her about repairs that are recommended? They need to find a different realtor. If the realtor is not communicating with Ms. Garcia, then they need to find a different realtor that will communicate with both parties who signed the listing agreement, both owners of the property.
Mr. Clark, I believe previously you and I had conversations about the repairs that your client said were necessary. That was one of her reasons that the house couldn't be listed initially.
We agreed that I was not gonna be okay with, we agreed that we were gonna list the house as is, and the realtor said that was okay. She also said that when listing it, it was okay to put it up as a 3D video for showing to make it more readily to be seen due to the fact that I have limited funds to be able to leave the house with gas and stuff, and my kids have homework. So I made it available to when the kids are at their father's, that showings are opens, which is still 3 days of the week. And I made it to where that they can do a 3D video of the home so that they still have access to see what the inside of the home looks like instead of having to be there physically and then set it up on a Friday or a Monday to be there, or a Friday and a Saturday to be there physically to see the home if they wanted to, which my realtor said would not affect the house selling.
Again, it's not the realtor who's.
Hold on. The court can't listen here both at the same time. Miss Garcia should reach out to the realtor officers. There's a realtor telling each party 2 different things. if the parties cannot agree, it makes sense to make repairs. If the parties cannot agree, then the home will be sold as is. It's a loss to both parties. If they cannot agree to make the repairs, then they'll be sold as is.
Your Honor,
So has discovery been concluded?
No, Your Honor.
The court will not schedule a trial date till discovery's been concluded. How much time do we need to conclude discoveries? Court will set another pretrial.
Your Honor, I believe because I have a set of interrogatories that I have held back, thinking I might not need to send them if we had resolution today. So those will need to go out. We have pending subpoenas, and there may be more subpoenas that go out as a result of the responses to the interrogatory. So I would ask for 45 days.
Actually, Judge, I'm going to need a little more than 45 days. Mr. Garcia recently purchased a home, and the documents that were provided indicated that his brother finances everything. So I may need to get his records.
Okay, so you want a pretrial in about 60 days then?
That would be great.
And hopefully the parties can communicate with their realtor. The court would encourage both of you you want to maximize any gain on the sale of that home. It'll benefit
Your Honor.
both of you.
One
So
second.
the court would suggest you make the repairs, but if you cannot agree, then it's going to be sold as is.
Your
Have the
Honor,
realtor do the 360 so they can show the house online.
You know, like if it's gonna be.
Your Honor, Mr. Garcia has something to say. Would the court entertain what Mr. Garcia would like to say?
You can talk with you, Ms. Nemec, and you can, if necessary, petition the court for other relief. We're going to give you another pretrial date in about 60 days. We do. How about 9 o'clock on December 13th? It's a Friday.
Yes,
13?
that works for me, Your Honor.
December 12th is a Thursday
Okay.
at 8:30.
Either do the 12th or the 13th, the Thursday or the Friday. What the council, your preference and the parties? That's better for work
Thursday.
schedule.
Thursday would work better for me.
Okay, Thursday then at 8:30, December 12th.
That's good.
Well, do you want the court to initiate a teleconference with council?
I would appreciate a teleconference, Your Honor.
Right, the court can have more frank discussions with council. So rather than Zoom, it'd be a teleconference. Court will initiate a teleconference with council on December 12th at 8:30. And both parties are asking the court to adopt the recommendation of Mr. Walker this morning regarding the repairs of this van. Is that correct?
Yes, Your Honor.
Yes.
All right. All right. Anything else to be addressed this morning, Ms. Nemec? Or Ms. Nemec, do you want to confer with your client to see what he wants before we conclude this morning? We put you in the breakout room.
If the court wouldn't mind, yes, I would appreciate that.
Okay. Okay. We'll put Mr. Garcia and Mr. Do you want Mr. Clark in there as well, or just your client?
I think just my client.
Okay.
Thank you.
Mr. Garcia in a breakout room with Ms. Nemec briefly. Okay, for the record, Ms. Nemec has returned after conferring with her client, Mr. Garcia. Ms. Nemec, was there another issue that needs to be addressed this morning?
Well, Mr. Garcia took issue with some of the things he heard Ms. Garcia saying regarding the repairs to the home. While we were in the breakout room, I did take the opportunity to reach out to the realtor. She did confirm for me via phone that she told the parties that the feedback she's getting is the house is in need of repair and updating, and that it either needed to be repaired or they needed to significantly lower the price of the home. She said she did tell both parties this while they were together at the time of signing documents.
Judge, notwithstanding, we don't believe she did that. I've talked with my client. We're in agreement that if Mr. Garcia wants to make the repairs, front the funds to do so, and my client will pay half of that out of the proceeds of the sale.
Okay. Thank you, Mr. Clark. That does make sense. So
Yes.
obviously the parties need to communicate in terms of, will Mr. Garcia do his repairs or is he going to hire someone?
He's going to hire someone, is my understanding. Is that accurate, Mr. Garcia?
yes.
Yes.
And obviously, if Mr. Garcia should share with your wife any estimates.
Right. I would like
We're not going to redo the entire home, but anything that recommended by the realtor, two of you need to share it and communicate about those repairs.
Absolutely. And Mr.
To the
Garcia, you
extent-
understand that, correct?
Yes.
Okay.
Okay, so but the extent that you don't agree to replace the roof, I mean, then that doesn't get done. So hopefully the two of you will agree to maximize your return on the sale of this home. in the court, and Ms. Garcia, you got to make, if realtors are contacting you, try to your best to make it work. I understand it's difficult with 5 children, but you got to try your best to make it work so the home is available. Sometimes purchasers, likewise, they've got a tight schedule and they don't give you a whole lot of notice, but please do your best to make the home accessible for potential purchasers. With that, the court would like to take the proofs in this matter because this case is getting old and like stop the clock. Mr. Nemec and Mr. Nemec and Mr. Clark, any objection to the court establishing jurisdiction has been a breakdown and that Ms. Garcia is not now pregnant, then we'll just stop the clock and the court will reserve all outstanding issues.
No objections, Your Honor.
No objections.
All right, Mr. Riz Garcia, can you both raise your right hand to be sworn, please?
Okay, and you are the plaintiff in this action for divorce, correct?
Yes,
And at the time that you filed your complaint for divorce, had you lived in the state of Michigan for at least 180 days and the county of Monroe for at least 10 days?
yes,
Okay. You and Ms. Garcia were married in Toledo on January 5th, 2012.
yes,
And you have 5 minor children, those children being Madeline, Morella, Xander, Zayden, and Zachariah Jr., correct?
yes,
Okay. And there are no other children born or adopted into this marriage?
No.
Okay. And to your knowledge, is Ms. Garcia currently pregnant?
No.
Okay. And are you alleging to this court today that there has been a breakdown of the marriage relationship to the extent that objects of matrimony have been destroyed and there remains no reasonable likelihood that the marriage can be preserved?
correct.
I have nothing further, Your Honor.
Thank you, Ms. Nemec. Mr. Clark, do you have any questions, first of all, for Mr. Garcia?
No.
Or if you could just confirm with Ms. Garcia that she's not now pregnant, please?
Please state your name for the record.
Michelle Ellen Garcia?
Ms. Garcia, are you pregnant today?
No, sir.
Thank you. Based upon the testimony that's been presented this morning, as well as the complaint filed in this case, court finds that jurisdiction has been established. Court further finds that there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed and there appears to be no reasonable chance of reconciliation at this point in time. The court at this time will reserve all outstanding issues and schedule this matter for a continued, hopefully a final pretrial conference via teleconference initiated by the court on December 12th, 2024, 8:30 a.m. Court will mail out notice. And court has adopted the recommendation of Mr. Walker this morning that we mail out to counsel. And Mr. Garcia, please continue to work together to not only get that vehicle repaired as soon as possible, so get back to Ms. Garcia for the benefit of the children, but also get the repairs done as soon as possible, the recommended repairs, and agree upon those.
Your
With
Honor,
that, yes, Ms. Nemec.
just a quick question. Were you having Mr. Walker add the agreements about making the house accessible for showing and the repairs for the home to his recommendation, or did you want me to draft an order?
I don't know if Mr. Walker is listening in right now. There's not, so I guess you can submit an order then, Ms. Nemec.
I will do that. Thank you.
Well, Judge, I'm not sure what the order was. My client has complied with what the realtor has said.
Right, the parties shall make such repairs as they can agree upon to the home, and also that Ms. Garcia will make the home accessible, reasonably, will make all reasonable efforts to make the home accessible to showings.
Pursuant to who? Pursuant to the realtor, we would assume.
The language I would use is that they will make the house accessible for showings per the realtor's reasonable recommendation. And I would say the same with regard to repairs, that they would make the repairs that the realtor says they should make. If it's not reasonable and it's not necessary to replace the roof, they shouldn't be doing that. But if the realtor says you need to make some, aesthetic repairs, you should do that to get the house sold.
Already made those things.
As long as everybody's cognizant of the fact that my client and 5 little kids live in the home, Judge.
It's
very
certainly
disruptive.
recognizable, but we need to liquidate this home. So let's get those repairs done as soon as possible. I understand it's difficult for showings, but just the court wants Ms. Garcia to use all reasonable efforts to make the home available. That's all we're asking.
I'm using the 3 days.
And the
that-
court suggests somebody should reach out to the realtor and have the realtor put in writing the recommended repairs.
We can do that. I just spoke with her, so I can make that phone call as soon as we're out of court and ask her to do that.
Okay,
Thank you,
all
Judge.
right. All right, that'll conclude this hearing. Everyone can zoom out.
Thank
Have a
you,
good
Your
rest of the
Honor.
afternoon.
Thank you. You too.
Stop the clock in that.
Coming in, Judge, they're asking for a trial date.
Yes or no? Okay. For the record, this matter is before the court for continuing pretrial conference subsequent to the parties having engaged in mediation. With Mr. Pratt for the front of the court this morning, this hearing is being conducted via Zoom. Present is Attorney Kirsten Nemec representing the plaintiff, Zachariah Garcia. Mr. Garcia is present, in addition to Attorney Teresa Olette is present, representing defendant Michelle Garcia. Ms. Garcia is present. Good morning, everyone.
Good morning, Your Honor.
Ms. Nemec, have the parties made any progress toward their own resolution this morning?
Unfortunately, Your Honor, no, they have not.
Okay. What is is there any value in a second mediation, or do you want simply a trial date?
Your Honor, this was our 3rd mediation. I think at this point, we need to set this for trial.
Okay. How many days do you anticipate the trial Ms. Nemec, 1 day? Could we do it in a day?
I think it would be at least 2. I think every issue will be preserved for trial. I don't think we have resolution on anything.
The court noted that in the pretrial statement some time ago, the only issues were spousal support, real property division, and pension benefits. Is
Right.
custody and parenting time now an issue?
It is.
It is.
Parties are going backwards.
Yes.
Mr. and Mrs. Garcia, I will tell you right now, obviously, if the two of you cannot reach your own agreement, which is far preferred rather than a trial date, it will create problems because when spouses testify against each other, they're always going to want to put the other parent in negative terms. You're going to start throwing stones at each other. Then you're going to start throwing rocks at each other, and it's going to destroy your relationship to co-parent your children. I can tell you that right now from past experience. But if in fact you want to put yourselves in that position, court can't do much about that. But I would encourage you to keep an open mind and reach your own agreement. And you sort of lose control because what this court will do is most likely just liquidate everything. We're not going to argue over a lot of items. We're just going to liquidate everything. Much easier to divide cash than to divide property. The home is on the market now. Is that correct?
Your Honor, an offer has been accepted. We've been back before the court a couple of times on this. We were here in early November.
Attorney Teresa Olette is present, representing the defendant wife and mother, Michelle Garcia, and Ms. Garcia is present. Good afternoon, everyone.
Good afternoon, Your Honor.
The court notes that there's a pretrial conference scheduled on December 12th at 8:30. The parties on this motion have conferred with Ms. Barr from the front of the court. The court received the following recommendation: that the defendant shall answer plaintiff's request for production of documents within 14 days. The court's aware that Ms. Olette is new to this case. Attorney Eric Clark previously withdrew as the attorney for Michelle Garcia. And further, that any prior orders granting payment of marital bills shall continue. Ms. Nemec, is this recommendation good with your client?
Unfortunately, Your Honor, no, it's not.
Ms. Olette, is this recommendation good with your client?
Yes, it is.
All right. What's the status of the sale of the marital home? Has that been listed?
It has, Your Honor, and the parties have received an offer. Ms. Garcia has refused to accept it. We did actually cover that when we met with Ms. Brower. I know it's not part of the motion that I filed. I filed that motion back on October 3rd, but the offer, I believe, was received around October 28th. That was prior to Ms. Olette being retained. Ms. Garcia refuses to accept the offer, and per the conversation before Ms. Brower today, she believes that the court's prior orders don't require her to accept the offer. I have myself spoken with the realtor. She has indicated to me that it is a good offer, that the parties have had something like 11 to 12 walkthroughs plus an open house, and this is the only offer that they have received.
Okay, first of all, Ms. Olette, you are agreeable with the recommendation that your client respond to plaintiff's request for production of documents within 14 days of today's date?
Yes.
Okay. With respect to the sale of marital home, have you reviewed the offer?
I have not gotten to fully review the offer. I just got added in as counsel. I know that opposing counsel sent me some emails back and forth that she had with the realtor, but I have not been able to review any offers.
I have the offer, Ms. Olette. I can forward it to you via email if you'd like.
Yeah, absolutely.
Okay, I'm sending that to you right now.
The court's opinion that this home ought to be sold. But yes, but the court will not order that without Ms. Olette, attorney for Michelle Garcia, reviewing that offer and talking with the realtor if necessary.
Yes.
Your Honor, if I may, the offer was a one-day offer. The potential purchasers have agreed to extend that offer through today. However, if they don't have a response today, the parties will lose the offer.
Well, like I said, I was just brought into the case, so I haven't had an opportunity to review it. This is the first and only offer that they've received. So I just want the opportunity to review it with my client to make sure that it's a fair offer. It's not a lowball offer.
I can tell you that they were offered $375,000, that they would like to close around November 28th, and they were offering Ms. Garcia 30 days of occupancy.
Is there any fair market analysis that was performed by the realtor?
I believe at some point, I'm sorry, Your Honor, I don't recall off the top of my head. I know that the fair market analysis was higher than the $375,000, but Ms. Hudson, the realtor, has indicated that the house has some serious need of repair, and given the need for those repairs, that she believes that the $375,000 is a good offer. I spoke to her about this on October 28th via email, and I forwarded that email to Ms. Olette last week on Friday.
Yes, and I haven't seen an appraisal.
I don't think we ever did an appraisal. The parties don't really have money for an appraisal. We did fair market analysis, I believe.
Oh, can you forward that to me as well? Because I don't have that also.
I can look and see.
Over to tomorrow. What time do we have tomorrow?
Is that accurate, Zach? that we did. Am I remembering this correctly? I'm not seeing it immediately.
They ran a fair market appraisal. The houses around me sold for 420,000, something like that. But that's without damages and everything that has to be done to the house.
It might be in
I do
here.
know that the court did also order that the parties review and agree to repairs reasonably recommended by the realtor.
Right, and they decided not to do any repairs, is my understanding. Is that correct, Mr. Garcia?
Yes.
Ms. Garcia, is that correct? That you and your husband agreed not to make any repairs? You need to unmute yourself, Ms. Garcia.
Yes, that's correct.
Okay, so let's address that. All right, the court's going to adjourn this matter to tomorrow morning at 8:45 or 9:45. When are you available, counsel? And the court's can make a decision, and you need to review that offer because the court's inclined to order that and Ms. Nimick perhaps can reach out to the realtor and ask for another 24 hours, or the realtor can reach out to the purchaser, see if they can extend this for another 24 hours. Are you both available at either 8:45 or 9:45 tomorrow? So in the meantime, Ms. Willett can review with her client next 24 hours this offer.
I can do 9:45.
Hold on one second. I'm sorry. My calendar is pulling up. I apologize. Lagging very much today. I will make 9:45 work tomorrow.
So we're next on notice, but simply I'm going to hold on to Ms. Brower's recommendation regarding the status quo about marital bills, or we can review the appropriate child support under the guidelines. I don't know if that's been reviewed. Ms. Brower, did the parties review the child support guidelines?
Your Honor, I ran child support and spousal support numbers this afternoon for the parties. The attorneys have the calculations.
All right. All right. So if you can hold on those calculations, hopefully you'll be available, Ms. Brower, to discuss the matters with the parties tomorrow at 9:45.
I will be in your court tomorrow, so yes, I will be available.
All right. So it's a matter that adjourned to tomorrow night.
The closing's tomorrow.
Oh, wonderful.
But that does
Okay.
raise an issue, Your Honor. We request that the proceeds from the sale be held in IOLTA because currently everything is at issue and there's nothing that's been agreed upon. And we have some serious issues with regards to some bank withdrawals after getting subpoenaed, the results of subpoenas from bank records.
Your Honor,
Any
if I may.
objection?
So, Ms. Olette, did you receive the 4 sets of answers to interrogatories that my office sent to you after the November hearing where we discussed this?
Yes, and we went through and tallied and got our subpoenas for the bank records. There is about $70,000 in withdrawals taken out outside of the $30,000 that's accounted for payment of loans and credit cards.
Any objection, Ms. Nemick, to placing the net sale proceeds into escrow, into a client trust account?
I have no objection.
All right, and who wishes to hold those funds?
I will hold them if that's fine.
That's fine.
All right, so the court will order that the net proceeds realized from the sale of the marital home, which is to occur tomorrow, which is December 13th, it shall be maintained in the deposit, maintained in the client trust account of Attorney Nemick.
Your Honor, in addition, we are going to need some temporary orders from the court. Ms. Garcia has indicated, so she has 30 days occupancy of the marital home, and that will end on January 12th. She has indicated she intends to move to the Dearborn Heights area. Mr. Garcia lives in the Trenton area, so neither party will continue to reside in the children's current school district. An issue at mediation this morning was where the children would go to school. The parties do not agree on that issue. Mr. Garcia would like to see them go to school in Trenton, where he owns a home. Ms. Garcia's intent is to stay temporarily with her grandmother. That's our understanding. And so her living situation wouldn't be necessarily permanent or stable. In addition, Mr. Garcia believes that the school districts in Trenton are superior to the schools that are available where she intends to reside in Dearborn Heights. I don't know, how long she would be there and if there would be a change in those districts if she found a permanent situation in a different area of Dearborn Heights. But at least temporarily, we are going to need to address that issue because as of January 12th, neither party will reside in the Ida School District where the children currently attend school. In
How old are the
addition,
children?
And we would object to that, Your Honor.
How old are the children, Ms. Nemick?
the oldest is 11, the youngest is 2, and there are 5 of them. So they range from 11.
And my
So 4 of the
client,
children are in school in Ida?
Currently, yes.
Okay. Ms.
my-
Olet?
my client is going to reside with her grandmother in Dearborn Heights schools. My client is the primary caregiver when it comes to the minor children's school. The fact of the matter is that dad during his parenting time has not been getting the children prepared for school. Instead, he's been bringing them back to Miss Garcia to get them dressed and ready for school at the conclusion of his parenting time, rather than taking them to school and having them properly ready. Further, my client has gotten messages from teachers saying that on dad's parenting time during the week, that the minor children are coming to school tired, and they're just not ready for school. So we would ask that school remain with mom, as she is the person who is getting the children to school, getting them prepared, doing the homework, taking them to extracurricular activities, participating in concerts and everything else with the children, and she will remain and continue doing so. So we ask that it be in Dearborn
Is
Heights.
Mr. Pratt still available? The court like to get a recommendation from Mr. Pratt this morning. In absent agreement, the court's inclined to suggest that children remain in Ida schools. Why should we disrupt their lives because of the parents? Mr.
Your
Pratt,
Honor,
do you have any recommendation for relative to school placement of the children?
well, my understanding is both parties are going to be living in Wayne County, so I do not believe Ida schools will allow the children to stay in the Ida school district. It's my understanding with both parties not even living in the county, they would not even be able to do school of choice. Currently, the parenting schedule is dad has 6 out of 14, mom has 8 out of 14. We struggled with this for a while, Your Honor, and I'm not sure which way that would go, because dad's in Trenton and mom's going to be in Dearborn Heights.
Understood, but again, the children are already enrolled in Ida. I don't think Ida's going to boot them out because a parent moves.
Once
How
mom
do they get
changes her
notified?
address, there's no guarantee, Your Honor.
Michelle, have you looked into whether the children can remain in Ida schools for the remainder of the school year?
I have, and they said that once school of choice opens up again, they could remain in Ida schools.
Well, that's usually at the beginning of a commencement of a new school year.
Yeah.
So unless the court receives a letter from Ida schools that they cannot continue after January, then the court's going to order that they continue in Ida schools.
Thank you, Your Honor. We would
You
prefer
have to
that
disrupt their
children.
lives.
Okay.
So if you want to prepare an order, Ms. Nemec, that unless the Ida school refuses to allow the children to continue, they should continue in the Ida schools. And the court suggests the parents don't make it an issue. If it's not an issue, the Ida school is not going to unilaterally hire an investigator to find out if someone's moved. You got to somehow transport the children to Ida schools every day. And if Mr. Garcia is late and not delivering the children on time, then the court will modify the parenting time schedule.
Your Honor, I would like to address that since it was stated on the record, and I'd like to remind the court that previously we had to argue when Ms. Garcia was represented by Mr. Clark. We were having trouble with parenting time while Mr. Garcia was exercising in the marital home because Ms. Garcia was going so far as to lock up food and toiletries. The reason Mr. Garcia was bringing the children back to the marital home to change clothes was because Miss Garcia was not allowing the children to have their clothes with them, and they were picking up the bus from the marital home. At this point, with Mr. Garcia living in Trenton and having a home of his own, as long as Miss Garcia doesn't continue to withhold the children's property, he would be getting the children ready for school and transporting them directly to school, not having to bring them to the marital home to retrieve clean clothes and get on the bus. So there should be no issue there as long as Miss Garcia doesn't withhold any property.
All right. All right. Hopefully the parties can work through these issues together. But if not, you're requesting we set a trial date at this time. Is that correct? In the trial court docket?
Yes, Your Honor, but we will also have one other issue that needs to be handled in the interim. We have a status quo in place. And obviously the marital home will be sold as of, well, it's sold as of tomorrow, but she won't be occupying it anymore as of January 12th. So we would like to see that status quo replaced with support orders. We'd have no problem with carrying it through for the remainder through January. Mr. Garcia gives her $350 a week, plus pays all of the marital expenses. We would like to see that continue through January, and then in February, spousal support and child support. We were unable, though, to run any new numbers this morning because it's my understanding the system is down.
Correct.
All right. What about if we simply refer the issue of child support and spousal support to the front of the court for an investigation recommendation?
I think that would be sufficient.
I don't have objection to that.
Okay.
You can include that in your order then, Ms. Nemec. If you get that order,
Okay.
We'll get that in as soon as possible, that the children should remain in Ida schools until further order. And what this court's looking at is we need something from Ida schools that they're removing the children from schools. And I doubt they will do that unless one of the parents contacts Ida School and say, oh, we're no longer living in Monroe County. I don't think that's going to be an issue. And then the children we need to minimize disruption for the children, Mr. and Mrs. Garcia. To make it work, even if one of you needs to, I don't know how long Mr. Garcia's lived in, obviously Mr. Garcia is a plaintiff, so he moved out of Monroe County shortly after filing the divorce complaint. Is that correct?
No, that's not correct, Your Honor. Mr. Garcia continued to, he stayed with family members and continued to exercise his parenting time at the marital home until just maybe 2 months ago, I believe, is when he purchased the home in Trenton.
Okay, well, maybe mom can find an apartment temporarily in Monroe County. So there's no issue with disrupting the children. Think about your children, Miss Garcia. And then Mr. Garcia, maybe you can find a temporary apartment. We're talking about, 5 months, 6 months. Let the children finish where they're at right now. Let's minimize disruption to their lives. All of a sudden changing schools, it's enough with the parents getting divorced, but it compounds that issue for the children when they're taken out of their school they've known and put in a whole new environment. So again, you can put that in your order that the issue of child support and spousal support shall be referred in front of the court for formal investigation recommendation. The sooner we get that court order entered, the sooner we can address that matter, hopefully in January.
Okay, thank you, Your Honor.
Let's get some trial dates, and we'll set it for 2 days. So we're probably looking at Thursday and Friday. Absolutely.
13th and 14th, Thursday and Friday.
How about February 13th and 14th? It's a Thursday and a Friday.
Hold on one
We
second.
need it to be sooner. They go on winter break.
That works for me, Your Honor.
Unfortunately,
Lett?
we already have something on the 13th.
They have a trial date on the 13th.
Yeah, so our calendar already has a date on the 13th. We have two, it's just myself and Miss Smith, and both of us have prior hearings on the 13th.
Okay, can that be moved? Is this a hearing? Can Ms. Smith handle the hearing?
No, I'm saying we have two. Both of us are covering a hearing on the 13th. The 14th is okay, but I don't have the 13th. I have the 11th and the 12th.
No, the court's docket days are Tuesdays and Wednesdays, so the court wants to do 2 consecutive days. So you're not available on the 13th, then, correct?
No,
Okay, and that,
I'm sorry.
how about the 20th and 21st of February?
May I speak? May I speak?
Just a moment, ma'am.
Those dates work for me, Your Honor.
Yeah, I'm okay with that day too.
All right, the court will set the 2-day trial, February 20th. It'll be in person, beginning at 8:30 each day. The court will request that the counsel submit trial briefs, exchange and submit trial briefs and exhibit lists on or before February 14th. Ms. Garcia, do you want to talk with Ms. Olette?
Yes, I would like to do that.
Okay, we give you a breakout room.
Thank you.
We're gonna bring Ms. Olette back out. Ms. Nemec, I don't want to keep you waiting. We also have another matter waiting right now. So unless she wants to discuss something with the 4 of you, we'll bring her out.
Okay. Your Honor, I believe that in order to release the escrow funds to me, they're going to need an order, and the closing is tomorrow. So I'm going to get that order prepared right away.
Okay,
And just send it over for signatures so I can get it to the
that's
closing.
fine. That's right. Ms. Olette is a consent to that on the record, so you can just submit it directly to the court for entry. So you have it for closing. Ms. Olette, I'm sorry, I've got another matter waiting.
Oh yeah, I'm sorry. My
so I just wanna bring you
apologies.
back out.
My client just has raised an issue that with regards to the schools, she said that it would be an hour drive for the children from Dearborn Heights to remain in Ida schools. So she asked that the court reconsider Dearborn Heights schools as that's kind of a
Now without hearing, Ms. Olette, the children will stay in Ida schools. So hopefully, it's going to be an issue for both parties and a greater issue for the children. This court's concerned about the children, not Mr. and Mrs. Garcia. So that will conclude this matter. Maybe the parties can talk and agree upon something in the interim. Maybe somewhere between Ida and Trenton. But the court's not going to make a decision without a full hearing on that, and that will occur in February.
Okay.
Do you want to talk with Ms. Nemec? If you like, I can put you all 4 in a breakout room if you want.
No, I can talk with Miss Nemick after. I can
Right.
give her.
Ms. Nimick's going to submit an order today for the court to sign, so we get an order for the closing agent that the net proceeds be held in escrow by Ms. Nemick. So she'll be submitting that today without your approval. And there'll be a separate order regarding the other issues, the schooling. Oh, and referring issues of spousal support and child support in front of the court, you do a separate order for that, Ms. Nemick.
Okay, or Miss Olet, if you're available to review it right away today and sign it electronically, I can combine it all into one. I plan to do it right now.
Okay, yeah, if you do it right now, I can do that. I have a hearing in Livingston at 1:30.
Okay,
I'll
all
go
right.
together right
That
now.
concludes this matter. Everyone zoom out. Have a good rest of the morning.
Yes, thank you, Your Honor.
For the record, this matter is before the court in the absence of Judge Lohmeyer. The parties apparently engaged in mediation this morning and have an agreement they wish to place upon the record. Present this morning is the plaintiff, James Holschuh. Is it pronounced Holschuh? Holschuh, right, and good morning, Mr. Holschuh. In addition to Attorney Kimberly Kunis, present representing the defendant, Kelly Holschuh. Good morning, everyone.
Good morning, Your Honor.
Ms. Kuhn, is it correct that the parties have engaged mediation this morning, which to place agreement upon the record?
That's correct, Your Honor. And thank you so much for allowing us to place that agreement on the record today.
Not a problem. Always be available to counsel and the front of the court. The parties have worked hard toward a resolution, and judges are not available. All right, Mr. Holschuh, Ms. Kuhn is going to place on the record what she understands to be your agreement. So listen carefully. After she does so, I'm going to turn to you and ask whether or not it's an accurate statement of your agreement. Okay?
Okay.
All right, Ms. Kuhn.
Thank you, Your Honor. The agreement is as follows. The parties are going to exercise joint legal custody of their child, Owen. Mom is going to be primary for medical decision-making, and the child shall attend school in mother's school district. Parenting time is reasonable and liberal for father per the agreement of the parties. And at this time, it's going to be supervised with maternal grandmother, with maternal uncle not being present. Kylie can also supervise and mother can supervise, but it's going to be 2 times a week and any and all other times that the parties can agree. There's some sensitive issues going on that I don't want to place on the record, just out of respect for Dad. So everybody discussed all of, what was going on in mediation, and everybody's really proud of what Dad's doing and very encouraged. So that's all I'm going to say about that. Father shall have video calls through Snapchat every day with Owen. If there are any field trips or open house or any other events at the school or daycare, Mom is going to let Dad know. And if Dad wants to attend, that would be awesome. And Dad can even go on the field trips with Mom. So holidays, Father's Days, days of special meaning, Mother's going to make sure that Dad will be able to come to the home and spend time and exercise parenting time with their son on those holidays. At this point, Mother's going to be responsible for transportation. The marital home, my client is going to assume the mortgage. And if and when she sells the home, she is going to pay husband $10,000 from the sale proceeds. Mother's going to be awarded all other remaining equity for the home. My client's going to be responsible for payment of the mortgage, utilities, taxes, insurance, and will indemnify and hold husband harmless from any liability pertaining to the home. Each party is going to retain their own vehicles, with my client receiving the 2020 Lexus. Husband is awarded the 2017 Dodge Ram and the 2020 Harley motorcycle. Each party is going to be awarded their own retirement accounts, free and clear of any claims by the other. If there's any loans that the parties have made from any of their retirement accounts, they're responsible for their own loans. With regard to debts, each is going to be responsible for their own debts. The only joint debt that the parties have is the mortgage to the home, which my client will be assuming. My client will assume that mortgage as quickly as she can. However, husband's not going to put a time period in which she needs to get it done, but she knows she needs to get it done. Each party will be responsible for their own debts. Each party is awarded their own bank accounts. Each party is awarded their own life insurance, except my client is going to be named as the irrevocable beneficiary on husband's military life insurance policy. Husband will provide wife with proof of beneficiary status by 12/31 of each year, and the parties have discussed privately if the money were to be received, that money would go to their son. With regard to personal property, husband is awarded all the items in the garage with the exception of the golf cart and the freezer. He's also awarded all furniture in the front room, his father's TV, his personal effects, the second bedroom, which has a bed, computer, desk, chair, and back living room TV. Wife is awarded all other personal property in the home and 100% of the property in the shed. The parties will work together in terms of when husband will pick up the property. Right now, husband does not have a home, so wife is aware that she may have his property for a while until he gets a home and is situated. And at that time, they will work it out. We do not need to reserve jurisdiction on that. Effective November 1st of 2024, father will pay mother child support in the amount of $881 per month. The parties are both providing health insurance coverage for the child. They will continue to do so. Any out-of-pocket after mother pays the ordinary medical amount of $454 per year will be 50-50 by each party. There is daycare costs for the child. Mother and father is going to pay mother 50% of the daycare costs for the minor child directly on Friday of each week. Spousal support, my client, there's a military pension and husband is receiving $900 a month. This was actually a pension that accrued during the marriage. So the parties have agreed that my client is going to receive the sum of $450 a month. It's going to be permanent spousal support from the military pension. It's going to be a direct pay, so husband will be paying wife that amount. Wife also, well, the parties during the marriage opted to have survivorship rights on the military pension, so there is a survivor benefit plan, and both parties will ensure that they make that election since they've already paid for that survivorship right so that wife can receive those funds. If husband were to die before her, they're going to make that election within 14 days after entry of the judgment of divorce. And the parties recognize that their military pension is a marital asset, and they will fully cooperating and effectuating the intent of each receiving half of the military pension during the life of plaintiff, and Kelly receiving that survivorship benefit upon his death. Mothers to claim owing on taxes as and for dependency exemption each and every year. Since the parties will be divorced prior to the end of the year, parties are going to be filing separate. Each will be awarded their own refund. Each will be responsible for their own liability. Each is responsible for their own attorney fees, and my client can restore to her maiden name of Kelly Marie Levesque, UER, if she so deems to do so. And I believe that is the agreement, Your Honor.
Thank you, Ms. Kuhn. With respect to the $400 direct pay spousal support, you indicate that's permanent. Is that non-modifiable?
Yes, it is. Thank you.
Non-modifiable in terms of amount as well as duration?
It's going to be non-modifiable, and I don't know if it goes up. It does not. Okay, so yes, non-modifiable as to amount and duration.
Okay, thank you.
Thank you, Your Honor.
Mr. Holschuh, did Ms. Kuhn accurately state your agreement?
Yes, there's just one thing I want to add.
Go ahead.
If by some chance my military pension does increase, I do want to get it adjusted so she gets half of that.
You okay with that? It's fine. Okay. I'll put however, if there is an increase, wife will receive 1/2 of that increase as well. Okay.
Right. With that addition and modification, Mr. Holschuh, did Ms. Kuhn accurately state your agreement?
Yes.
And then you understand that if the court accepts the agreement this morning, that you'll be bound by the agreement. There'll be no trial in this matter. Do you understand that?
Yes.
Okay. Has anyone promised you anything or threatened you in any way in order to get you to come to this agreement?
No.
Right. Mr. and Mrs. Holschuh, can you both please raise your right hand to be sworn, please? Do you both solemnly swear or affirm that the testimony?
Brookshire Street address, the marital home that we've referenced in the judgment.
Yes.
You heard the agreement that was placed on the record, correct?
Yes.
You have one child, that being Owen. How old is Owen?
2.5.
And you understand that you and your husband are going to exercise joint legal custody with you being the medical decision maker. But you understand that that still requires you to discuss all major decisions, including medical decisions with your husband, correct?
Yes.
You also understand that the agreement calls for a permanent spousal support award that's direct pay to you.
Yes.
So you understand that your husband is going to be making that direct payment every month at the time period in which he receives that amount from the military, correct?
Yes.
You understand that spousal support is forever barred as to your husband. So he cannot ever petition the court for spousal support, but you're awarded permanent spousal support when it comes to that payment.
Yes.
With regard to the property settlement, do you understand all of the terms and conditions of the property settlement?
Yes.
You understand that you need to take steps to assume the home, correct?
Yes.
And have you spoken to the bank and have you been approved for an assumption of the home?
Not yet. I got the application though.
If you cannot assume the home, you will have to refinance the home.
Correct. Yes.
How long do you need to refinance the home if you cannot assume it?
A year.
Mr. Holschuh, are you okay with her taking a year to refi if she cannot assume?
She can take as much time as she needs.
Okay.
Let's put 1 year in the judgment then, Ms. Schoon, so we have a specific time frame.
Yep, I'm doing that right now. With regard to the personal property, you understand that your husband does not have a home yet, correct?
Yes.
And you understand you're going to be hanging on to his property until he does.
Yes.
Do you have any questions regarding any of the terms and provisions of the agreement that we placed on the record?
No.
Did anyone promise you, force you, or otherwise induce you into entering into this agreement?
No.
Do you believe that the provisions related to Owen are in his best interest?
Yes.
Are you asking the court to adopt the agreement and make it an order of the court?
Yes.
Are you satisfied with my advice and counsel?
Yes.
You understand that had we had a trial in this matter, the result could have been the same, could have been different, better, or worse.
Same.
Notwithstanding this fact that it could have been different, you understand it could have been different if the judge is deciding.
Yeah.
Could have been different. Notwithstanding that fact, are you asking the court to adopt this agreement and make it an order of the court?
Yes.
No further questions.
Take your proofs. Okay. Thank you, Ms. Kuhn. Mr. Holschuh, can you please state your name and current mailing address for the record?
James Allen Holschuh.
Okay. All right, Mr. Holschuh, did you hear the testimony this morning of your wife, Kelly?
Yes.
Was her testimony true and accurate to the best of your knowledge?
Yes.
And do you believe this settlement you've reached with her to be fair and equitable?
Yes.
Do you have any questions for the court?
No.
Do you have any questions for Ms. Kuhn?
No.
Ms. Kuhn, do you have any questions for Mr. Holschuh?
I do not, Your Honor.
You'll prepare the judgment of divorce, is that correct, Ms. Kuhn?
I will.
How will you submit that to Mr. Holschuh? Will you submit that to his, for his approval, or you submit that in a 7-day rule?
I'm going to get it done and submit it to him. He knows that I don't represent him, but there are going to be some boilerplate provisions in the judgment. I told him that if he had any questions, since he's representing himself, I can answer those questions as best as I can. And I will email it to him. If I don't receive a signature back, then I am going to submit it to the court under the 7-day rule.
Okay, all right. Do you understand that, Mr. Holschuh, Ms. Kuhn's going to reduce all of this to writing and for a judgment of divorce? And there will be other provisions that are required in any judgment of divorce. For example, your wife cannot leave move more than 100 miles away. She can't leave the state without approval of the court and you, things like that nature. So Ms. Kuhn's going to prepare this judgment. She can submit that to you. If in fact you have questions or problems with it, you need to call her and let her know that.
I understand.
Explain that to you, but again, that you'll be bound by the agreement, the terms of which have been placed on the record this morning.
Your Honor,
Ms. Quinn, is there any other dates set before Judge Lohmeyer? Any other future pretrials or anything?
don't think we do, but I do want to question the plaintiff with regard
Please.
to.
I'm sorry.
Yeah. No, that's okay. Jimmy, as I stated, you understand that I'm not representing you, correct?
Yeah.
And you have decided to proceed in this action, representing yourself, correct?
Yes.
You understand that you would have the right to have an attorney. Are you waiving that right to consult with an attorney and proceeding on your own today, representing yourself?
Yes.
And you're not under the influence of any medication or any substance that would render you incapable of understanding this agreement?
No.
Do you have any questions regarding any of the terms and conditions of the agreement?
No.
You understand that both of you are awarded your retirement accounts, free and clear of any claims of the other, correct?
Yes.
You also understand that with the house, that when and if your wife sells it, that's when you would receive the $10,000. You understand that. So there's no definitive time period in which your wife needs to sell that home, correct?
Yeah.
Okay. And you've made a full disclosure of all assets and debts, correct?
Yes.
Do you believe that the joint custody provision is in the best interest of Owen?
Yes.
And you understand that you and Kelly will have to confer with each other regarding any major decisions with your son, correct?
Yes.
Are you asking the court to adopt the agreement and make it an order of the court?
Yes.
And you understand too that had you gone to a final hearing in this matter, the result could have been different. It could have been the same. It could have been better or worse.
Yes.
Notwithstanding that fact, you want this agreement entered.
Yes.
Okay. Thank you, Your Honor.
Thank you, Ms. Kuhn. You'll prepare the judgment then. The court applauds. I would like to thank Mr. Pratt for her assistance this morning, as well as Attorney Kuhn. And the court applaud the two of you, Mr. Holschuh, for reaching your own agreement without question. The best resolution of matters of this nature, one which you both participated, as you have this morning. Far better off to have the court make these decisions. Based, however, on the testimony that's been presented this morning, as well as plaintiff filed this case, the court finds that jurisdiction has been established. The court further finds that there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed, and there appears to be no reasonable likelihood that the marriage can be preserved. Accordingly, upon receipt of the judgment, the court will sign that judgment, and at that time, the court will order that the marriage between the parties be dissolved. The judgment shall enter granting a divorce from bonds of matrimony. Good luck to both of you. That will conclude this matter. You can both zoom out. Have a good rest of the day.
Thank you,
For
Judge.
the rest of this matter is before the court for a continued pretrial conference, same as being conducted via Zoom. Present is Attorney Maria Zagorski, representing the plaintiff, Amanda Hussen. Ms. Hussen appears to be present with Ms. Zagorski. In addition, Attorney John Danielski is present, representing the defendant, Kyle Hussen. Mr. Hussen appears to be present as well. Good afternoon.
Good afternoon, Judge.
The parties mediated with Ms. Patrick. Have the parties been able to make any progress toward resolution of any issues?
They have not.
Unfortunately, no, Your Honor.
Well,
I'm
Your
sorry?
Honor, there was some discussions between the parties of a settlement. I'm not going to get in necessarily to the details because confidential. Apparently, there's a misunderstanding between the parties as to what they thought they might agree to. And my thought process was that the parties maybe need to talk a little bit more because there apparently was a misunderstanding about what they were talking about. So I had suggested maybe come back in a couple of weeks so the parties had some time to talk a little bit.
All right. Did you discuss with Ms. Patrick her availability in a couple weeks?
I suggested it. I didn't get any availability. So I was hoping as Your Honor may know, I'm going out of town on the 17th of October. I was hoping maybe to try to come in before I go out of town.
I have availability, Your Honor, on October 2nd. I can do it at 1:30 in the afternoon.
The 2nd.
Or excuse me, the 10th. I can do it on the 10th in the afternoon at 1:30.
I could do the 2nd if it was later in the afternoon. The 10th, Your Honor, I have a trial in front of Your Honor that day. So
I'm with Mr. Walker on the 2nd.
The 10th must be a morning trial because the court will not be here in the afternoon.
Well, then I could do it in the afternoon then on the 10th.
I'm not available.
Not be available, and I'm reluctant to have the probate judges are overwhelmed. They can't certainly entertain any agreement. So I'd rather try to schedule something in the morning.
I Can I throw a date out, Patrice?
Yes, go ahead. Yes.
The 14th in the afternoon, I'm available. The 15th in the afternoon, I'm available.
As long as you can find a judge, Mr. Jandowski, this court will not be available after 2:30
On those 2 days.
for the entire month.
Okay. Oh, Your Honor.
I can do the morning of the 14th, Mr. Danowski, if you can do it.
I will be out of town.
Okay.
Let me
What about the 7th, October 7th in the morning?
I'm wide open on the 7th.
Ms. Gorski?
I have a 9 o'clock consult that I can move.
Well, you know what? How about if we start at 9:30?
Sure.
Okay, so 9:30 on the 7th. Thank you, Your Honor.
Thank you, Your Honor.
Court appreciates the willingness of the parties to continue their discussions to eliminate any misunderstandings. So the court will order that the parties meet with Mr. Patrick one more time on October 7th at 9:30 via Zoom, and thereafter appear before the court for continued pretrial conference.
Thank you, Your Honor.
Is there anything further the court can do this afternoon?
Well, the parties are talking, and I was hoping that they talk amongst themselves, because overall they seem to be getting along fairly well. So my that was my thought process. Maybe give it a couple of weeks so they can talk a little bit more.
All right. Okay. Certainly. And obviously, Mr. and Mrs. Hussen, both your attorneys can assure you that the best resolution of matters of this nature is one which you both participate and ultimately agree upon. Far better off than throwing things up there and have the court decide these matters. So keep an open mind and do communicate. All right. With that, the court will notice October 7th at 9:30. Thank you, Ms. Patrick, for your flexibility and pretrial following. And I'll be here until at least 2:30 that day. All right.
Thank you.
That will conclude this hearing. Everyone can zoom out and have a good rest of the afternoon.
Thank you. Appreciate it.
Your Honor. Good morning, Your Honor.
Good morning, Judge.
Good morning, Ms. Gorski. How are you?
I'm all right. How are you?
Good. It's got to be somewhere at noon, so I am sorry to interrupt. If we need more time, I can be back at 1:15.
I don't know where Mr. Danielski and his client are. 1:15 is fine with me.
Right.
Hussen's coming in now. He should be coming in any minute.
There they are.
For the record, this matter is before the court for a pretrial conference. Up to the parties have engaged in mediation with Ms. Patrick from the front of the court this morning. This hearing is being conducted via Zoom. President is Attorney Maria Zagorski, representing the plaintiff, Amanda Hussen. Ms. Hussen is present. In addition, Attorney John Danielski is present, representing the defendant. Kyle Hussen and Mr. Hussen is present. Good morning, everyone.
Good morning.
Don't mean to cut things short this morning, Mr. Danielski, but the court has an appointment at 12 noon, so I've got about 5 minutes. I can be back at 1:15 if the parties want to continue their discussions.
We have an agreement, Your Honor.
She's available.
We have an agreement. I don't know if we might be able to do it in like 3 or 4 minutes, put it on the record.
Okay. Right. Is that correct, Ms. Garcia? The parties have reached an agreement?
I believe so, yes.
Wonderful. Who would like to state the agreement on the record?
I'm happy to do that, Judge. I've got plaintiffs, so I can do that.
Please, Ms. Gorski.
Yes, thank you. The parties have 2 minor children, as you know. They've agreed to share joint legal custody of those children, and they will exercise parenting time on a week-on, week-off basis. They'll use the front of the court holiday schedule unless otherwise agreed. Effective November 1st, Mr. Hussen will pay $410 in child support per month based on that 50-50 arrangement. And the uninsured medical expenses will be shared 30-70 with my client responsible for 30%. Also November 1st, Mr. Hussen will pay spousal support in the amount of $314 for 3 years, 36 months. And that will be non-modifiable as to amount and term, and spousal support will be barred as to him. He will not be entitled to spousal support. The parties have a home that will be awarded to my client, and to buy out Mr. Hussen's equity, she will pay him $30,000. He will vacate within 30 days of receiving that money. She also needs to get his name off the mortgage, and she will have 6 months to do that. If she cannot do it, the house will be sold, and he will get his $30,000 at that time. No, because she's going to pay him $30,000 before that. She'll have 6 months to get his name off the mortgage, and if not, the house will be sold and the proceeds will go to her because he will have had his equity. Thank you. Personal property will be divided as agreed. The parties will share the exemptions for the minor children, with each taking one. When one child remains, my client will take even number tax years and Mr. Hussen will get odd number tax years. They will share extracurriculars, my client paying 45% and Mr. Hussen paying 55%. The parties agree that both children play hockey. They will also share the cost of tournaments with that ratio. We are going to divide any marital portion of any retirement account. Mr. Hussen represents that he has none except for his retirement with the military. And so we will divide the marital portion 50-50. We'll use Ann Pastrana and share the cost if that is worth being divided. We need more information about that. They'll each keep their respective vehicles. My client has a Toyota Tacoma. Mr. Hussen will need to sign the title because it's titled in both parties' names, but that's awarded to her. Mr. Hussen is awarded his 2021 Ram 2500 and the debt on that. He is further awarded the camper and the motorcycle and the debt attached to those. They'll each keep all remaining debt in their respective names, and that includes money loaned to them by my client's mother and other family members to Mr. Hussen. We'll have permissive language regarding restoration of Bronson to my client, BRONSON. She will take her First Heritage and Navy Federal Credit Union accounts, and Mr. Hussen will take his USAA accounts, including the dirt bike debt. And I believe that's the parties' agreement.
Thank you, Mr. Gorski. Mr. Danielski, did Mr. Gorski accurately state your client's agreement?
Your Honor, I need 15 seconds to talk to my client.
All right, court will resume at 1:30, 1:15.
Your Honor, I can ask him right now. It was the non-modifiable
Okay,
spousal support.
Okay, go ahead, Mr. Danielski.
I hate to ask him right on the record. Kyle, she's asking that the spousal support be non-modifiable for 3 years. That wasn't discussed before. It was spousal support, but it's the first time I heard non-modifiable. Do you want to think about it and come back at 1:15, or it's up to you?
No, just get it over with. I'm fine with it.
Okay, and then Your Honor, just
it's not modifiable in terms of amount as well as duration, correct?
That's my understanding. Yes.
Mr. Hussen, you understand that? So it's $314 a month for 3 years, non-modifiable.
Yes.
All right.
Yes, sir.
And then,
Right, thank you.
And then, Your Honor, I just want to verify that Ms. Zagorski said agreed upon extracurriculars. Obviously, everything they're doing right now is agreed upon. And then I think she said that. And then Ms. Zagorski said retirement military. I said she's entitled to half the marital portion, whatever he has. I don't think he has any military retirement, but whatever he's got, she's entitled to half the marital portion. And then the last thing she said, loan from like a family member. I believe that was to Miss Hussen, and I believe she's paying that loan. But and then if he's got loans from his family members, he's going to pay that, and then they're each going to pay the debt in their own name, except for whatever they receive, vehicles or whatever. They obviously have to pay for she pays the house even though the debt is partially in his name. So other than that, and then each party keeps their own financial accounts. That was it, Your Honor.
All right, thank you, Mr. Danielski. Mr. Gorski, are those modifications, clarifications acceptable?
Yes, I think that's everything that I already said. Yeah, it's fine.
For all, Mr. and Mrs. Hussen, can you both please raise your right hand to be sworn, please?
Thank you. Amanda, do you remember signing a complaint for divorce on April 12th of this year?
Yes.
At the time, you have to say yes loudly.
Yes.
At the time that you signed it, had you been a resident of the state of Michigan and the county of Monroe for 180 days?
Yes.
Is it true that there's been a breakdown of the marriage relationship?
Yes.
Have the objects of matrimony been destroyed?
Yes.
Is there any likelihood that this marriage can be preserved?
No.
You and your husband have 2 children, correct?
Correct.
No other children born or adopted by you?
No.
Are you pregnant?
No.
You heard the agreement that was stated on the record today, correct?
Correct.
You understand it?
Yes.
Do you believe it to be fair and equitable?
Yes.
Are you asking the court to adopt it?
Yes.
You understand that it will be final and binding if the court accepts it today,
Yes.
and we can't go back and modify the property settlement?
Yes.
Okay, you can't come back and ask for more spousal support or a different amount to pay Mr. Hussen out of the house. You understand that?
Correct. Yes.
You understand he's getting the equity in the camper and the motorcycle,
Yes.
and you're okay with that?
Yes.
And do you believe the custody and parenting time to be in your children's best interests?
Yes.
You understand that if it doesn't work for your children, that the court does have jurisdiction over that, and you can return to ask that that be modified?
Correct. Yes.
Okay. Have you disclosed all of your assets?
Yes,
Do you have any questions of me?
I do not.
Okay, thank you. That's all I have, Judge.
Thank you, Mr. Gorski. Mr. Danielski, do you have any questions, first of all, for Ms. Hussen?
No, Your Honor.
Questions for Mr. Hussen, please.
Kyle, do you believe that the agreement, considering everything we talked about, is fair and equitable to you and Ms. Hussen?
Yes, sir.
Do you believe that the agreement is in the best interest of your children?
Yes, sir.
And are you asking the court to adopt it?
Yes, sir.
No other questions, Your Honor.
Thank you, Mr. Danielski. Ms. Gorski, do you have any questions of Mr. Hussen?
No, thank you, Judge.
The court would like to thank and acknowledge Ms. Patrick for her assistance this morning, helping facilitate ample resolution, as well as, of course, the attorneys Zagorski and Danielski. The court would applaud you, Mr. Hussen, for reaching your own agreement. Ultimately, the best resolution of matters of this nature is one in which you both participate, as you have today and previously, and reach your own agreement. Based upon the testimony that's been presented, however, as well as claim filed in this case, court finds that jurisdiction has been established. Court further finds that there has been a breakdown in the marriage relationship to the extent that the objects of matrimony have been destroyed and there appears to be no reasonable likelihood that the marriage can be preserved. Accordingly, upon receipt of the proposed judgment, the court will sign that judgment, and at that time, the court will order that the marriage between the parties be dissolved and judgment shall enter, granting a divorce from bonds of matrimony. Ms. Gorski, you'll prepare the judgment. Is that correct?
I will.
Thank you again, Mr. Gorski and Mr. Danielski. Good luck to you, Mr. Hussen. That will conclude this hearing. You can both zoom out. Thank you.
Thank you.
Thank you.
Thank you, Your Honor.
For the record, this matter is before the court for the purpose of review. Subsequent parties have engaged in mediation with Mr. Pratt for the front of the court. The hearing is being conducted via Zoom. Present is Attorney Christine Hills, representing the plaintiff mother Chelsea Flood. Ms. Flood is present. In addition, Attorney William Godfrey is present, representing the defendant father Milos McGilvery is present with Mr. Godfrey. Good afternoon, everyone.
Good afternoon, Judge.
The primary issue is parenting time. Is that correct?
That is correct, Judge. This was originally before Your Honor on my client's motion. Ms. Flood was not available for that, so we put it to a mediation with Ms. LaPrade today. We were not able to reach an agreement at the mediation, Judge.
That is correct.
So are you requesting an evidentiary hearing?
We'll have to have one, Judge.
I'm sorry?
I believe we will have to have one. I mean, I can make the argument based on the motion that I had filed.
Well, Your Honor, I don't believe there's been a sufficient change of circumstances shown to even get us to an evidentiary hearing. Essentially, the allegations of changes of circumstances were manufactured by father. We've been able to refute those with the letters that we attached to our motion. I mean, right down to him claiming that he was up to date on child support. We were able to refute that with friend of the court records, a letter from the child's tutor, a letter from the child's teacher, refuting those allegations. So we do not believe that under Shade versus Wright or certainly Vadvarka that there's even a basis for the court to entertain this matter at an evidentiary hearing, and we're asking that the motion be dismissed.
Right. Of course, it's a parenting time issue, so it's a more relaxed standard of Shade.
Right.
Mr. Godfrey, the allegations that the mother was not keeping homework current with the child's at Meadow Montessori, is that correct?
The child is now at Meadow Montessori, Judge. The child had been in the airport school district before this. And was, I mean, a lot of the issues were the failure of mother to communicate with father. I mean, she had signed him up for karate and tutoring and had surgery on his foot and football, and even changing to Montessori school, advised the child about that before even discussing it with dad. Those are all kinds of things. Now we've got an app in place, and hopefully that will change it. But if you look at the very, very first court order, it was joint legal, joint physical. And
correct. January 2018.
Yes. And then mother went to Bahamas, and father would like the joint legal and joint physical and have equal parenting time.
I'm sorry, that custody is not changed, has it? Still joint legal, joint physical?
Yes, Judge.
The
it's just a
custody
parenting time.
Your Honor, the custody has not changed, but the number of overnights being requested in father's motion would amount to a change of the established custodial environment of the child. So still requires the higher Vadvarka standard with regard to that level of a change. Smaller changes of parenting time, I don't dispute, would be subject to shade. But the request that what he's asking for in terms of 50-50 parenting time throughout the year, by my calculations, adds about 84 overnights during the school year alone, which certainly would amount to a change of this child's established custodial environment and bring Bodvarka into play. So I believe that the focus, instead of on that joint physical language, should be on the impact of the established custodial environment.
Judge, with Ms. LaPrade, my client did indicate that he would agree to an additional, making it a Wednesday instead of a Thursday, as opposed to a complete week on, week off. Summer is already a 2-2-3, which basically summer is an equal parenting time. It's the school year. And the court did indicate that a 2-2-3 during the school year was a lot of movement for the child. And I discussed that with my client, and he can understand how the court would conclude that a 2-2-3 during the school year may not be in the child's best interest. So my client has indicated, at least with Ms. LaPrade, that there's no reason why he cannot be involved more with the child, and he would consent or request the court to order that he would have the Wednesday added to his current Thursday, which is current parenting time is every other Thursday after school or 9 a.m. if there's no school, until Monday to school, or 4:30 p.m. if there's no school. My client would agree to change that or add just Wednesday, so it would be every other Wednesday through Monday to school.
Your Honor, I would just reiterate that we do not believe that there has been a sufficient change of circumstances, even under shade, to modify parenting time. This order was just entered in November of last year. It's been less than a year. It's been one school year. The court did indicate at the time the last order was not entered, but at least the hearing on it last August, this child did need stability during the school year. So we don't believe at this point that there is any basis for changing it, or that any change would be able to be proven to be in Calvin's best interest. He's just starting at a new school. He's got a lot of changes going on in his young life at this point. He's involved in some extracurricular activities. He's being driven quite a bit farther by both parents to get to school, although I think both parents agree that the change to Meadow was a good one for him. So from my client's standpoint, it's just not the right time to even be considering this. We would certainly consider a week for vacation during the summer, something along those lines, so the dad could have some extra time. But changing things during the school year, A, we believe is not legally supported, and B, would not be in his best interest. And just a note on the communication issue, that's a two-way street. Mr. McGilvery needs to communicate back with my client as well, instead of ignoring communications that she sends to him. I'm hopeful that moving forward with some guidance to both of them today from attorneys and Ms. LaPrade, that will get better, that they'll start using the calendar function of AppClose. But I don't think that in and of itself is enough to justify modifying parenting time either.
Both parents agreed that the child should be at Meadow Montessori. Is that correct?
Yes, Your Honor.
Judge, my client agreed to it after already being told by mother that she had already enrolled him in Montessori.
Well, of course, if he objected, he could have objected, and the court could have conducted a hearing on the school choice if the parties could not agree upon that major important decision for the benefit of the child. But seems like we've already gone past that deadline now, because
that is correct, Judge. We understand.
To school. Okay, the only alleged change of circumstances is the school assignment, Mr. Godfrey.
Well, there was also, Judge, the failure, to communicate dealing with karate, tutoring, surgery on the child's foot. There was surgery, never advised Dad of any of this.
That's certainly a violation of the joint legal, and that Ms. Flood should and ought to, and perhaps you discussed that with your client, Ms. Sills, that she should and ought to. She had an obligation to inform Dad of those important decisions.
May I?
Consult him.
May I? He was made aware. He went to the doctor's appointments. He was at the surgery. There was full discussion before.
Right. Fair to inform a party of those kind of things. And so the court is not convinced, Mr. Godfrey, there's a sufficient change of circumstances to warrant a hearing to modify parenting time. And during the school year, and the court again is concerned about the back and forth, but obviously Ms. Flood is opposed to an additional overnight and alternating weeks. So at this time, the court will deny the motion to modify parenting time. Parenting time will continue as previously ordered.
Thank you, Your Honor.
Further, Mr. Godfrey?
Nothing, Judge. We disagree with the concept of the ruling of the court, but that is fine, Judge.
Okay, well, if there's future changes and there's issues at school, Mr. McGovern can bring it back before this court. But at this point in time, the only one allegation about the school issues. Apparently that's been refuted, allegedly. So the child is doing better in school right now. It remains to be seen, I suppose.
He's adjusting, Your Honor, according to my client, and everything is moving in a positive direction. But the Montessori philosophy, and I can speak from some firsthand knowledge with regard to my kids, it's a lot different than the traditional public school education. So he's adjusting, and I think with the support of both parents, he'll do very well.
Well, and if circumstances if there issues continue to exist, then Mr. Godfrey can bring the matter back before the court. The court will look at it again. But at this point in time, the court will deny the motion to modify parenting time for the reason that there's not a sufficient change of circumstances to warrant an evidentiary hearing. Ms. Sells, you'll prepare an order to that effect?
I will, Your Honor. Thank you.
All right, now we'll conclude this hearing. Everyone can zoom out. Have a good rest of the afternoon.
You too, Judge.
Thank you.